Good evening, grand jury and Jural assembly and jury members and court officials. I'm so glad that all of you are here tonight. Here we are on training number 8. Tonight I'm going to be going over court of record. There's many of you that are doing courts of record, and many of you have, well, not many of you, a couple of you have sent them in to me. Some of you are doing letters. Challenging jurisdiction by one-page letter. I have a couple of you doing that. I don't have templates on that, but when they get done sending theirs in, we will have theirs as a template. So we will have those. But tonight on court of record, I just want to go down. When you do a court of record on common law, there's going to be actions or causes of actions that you have in a case. So for us in common law, where the de facto says charges, we say actions or causes of actions. And so I'm just going to take a minute tonight, and this teaching shouldn't be very long because I want to kind of just go over it, and then I want to ask you guys if you have any questions or if you want to discuss some of this, because many of you are putting these things together. So I want to answer as many questions or make sure you guys are progressing good. So trespass. So on most of your court of records, you're going to have a trespass, and trespass on the case are going to probably be the most common in most of our cases. A trespass is when an injury is committed with force, actual or implied, immediate, and non-consequential. If property is involved, then property was in actual or constructive possession of plaintiff at the time of injury. So that's trespass. So trespass is going to be an injury with force or violence. A trespass on the case is going to be in practice. It's the form of action by which a person seeks to recover damages caused by an injury unaccompanied with force, or which results indirectly from the act of the defendant. It is more generally called simply case. So a lot of times you'll see it when you look at the common law court of records, it'll say case instead of trespass on the case. So basically, for me, the best way that I can tell those two apart is basically a trespass is once you've challenged jurisdiction, anytime you've challenged jurisdiction, it's automatically going to end up being a trespass against you, because challenging jurisdiction, they have exceeded their jurisdiction by taking action against you once you've challenged jurisdiction. So any action that they take against you once you've challenged jurisdiction is going to be a trespass, or it's going to be a trespass on the case. So for instance, or not all times, but for most of ours, which is road traveling, driver's license stuff, most of those are going to be that. But it's trespass. That's when they cause you injury. So once you've challenged jurisdiction, if they put a warrant out for your arrest, that's a trespass. If they hold a bond revoke hearing, that's a trespass. A trespass on the case on those instances is like when they ordered a strike, or if they hold some sort of like meeting, because sometimes when you read through their dockets, it'll say, oh, well, we were just having a meeting to update ourselves on the case, and you'll have the clerk's notes. That's going to end up being a trespass on the case because it didn't hurt you violently, but at the same time it's trespassing on you because they're not supposed to take any action whatsoever against you or move forward in any way on the case until they prove jurisdiction. And any action that they take is going to end up falling into one of these. So trespass and trespass on the case are supplementary to each other, and it may be said that in general, trespass on the case lies where no other theory of form of action is available, though it's sometimes concurrent with other forms. So you can use this one that's saying that if you don't know one of these that'll fit, you can utilize trespass on the case. It kind of fits where nothing else, you don't know what to put, it'll fit it. Trover. So a trover in practice is a form of action which lies to recover damages against one who has without right converted to his own use goods or personal chattels in which the plaintiff has a general or special property. So if the plaintiff, so if one of you guys, let's just say that they took let's just say one of the judges came and they took your car and they impounded your car. Instead of impounding the car, the judge is driving it around. See, he's using it for his own use. Or if for horses or anything that is your private property that the defendant is now taking that and converted your property into something for their own use. So an ejectment in practice is a form of action by which possessory titles to corporeal hereditaments may be tried and possession obtained. A form of action which lies to regain the possession of real property with damages for the unlawful detention. So this is when, if you're trying to get back real property, this is going to be like if they've taken your house, and so you're trying to get your real property back. And so this is going to be real property. So ejectment. Detenue in practice is a form of action which lies for the recovery in specie of personal chattels from one who acquired possession of them lawfully but retains it without right, together with damages for the detention. Okay, so on this one, let's say that you rented, so I'm trying to make an example of this. Let's just say that you rented someone, leased out your car, someone had to borrow your car, and they had possession of it, and they wanted to borrow it for 2 months. And so they paid you 2 months' worth to borrow that car, but then once that 2 months is over, they didn't pay you for a third month, but they still have the car. So they acquired the possession of that car lawfully, but now that they quit making payments and their 2 months is up and haven't retained it, now but they still retain it because they still have the car. Now they retain it without right. So, and then you get damages for the detention. So the part that you would get damages on is that, okay, let's say that the defendant ended up keeping your car for, you only rented it to him for 2 months. And so once that 2 months is over, it's now the third month, and let's say he's 2 weeks in and still haven't returned that car, then in essence you would say, okay, so you're going to have to pay me for that car. And what if he wrecked it? Then they would have to do damages for the wreck or the detention or whatever for that item. So that's going to be detenue. Replevin. Replevin in practice is a form of action which lies to regain the possession of personal chattels which have been taken from the plaintiff unlawfully. Well, this is an easy one. So replevin, we can utilize that with the horses. A form of action, this is a replevin of trying to get something back that they took and regain the possession of personal chattels which have been taken from the plaintiff unlawfully. So it doesn't matter what it is. Anything that's taken, it could be animals, children, cars, money, whatever. Debt in practice, a form of action which lies to recover a sum certain. It lies wherever the sum due is certain or ascertained in such a manner as to be readily reduced to a certainty, without regard to the manner in which the obligation was incurred or evidenced. So this is going to, this is debt. This is going to be money. So you're trying to get back money and recover what was not given you. And then covenant. The action of a covenant lies for the recovery of damages for a breach of a covenant. That is a promise under seal, whether the damages are liquidated or unliquidated. When the damages are unliquidated, it is the only proper form of action. Okay, so this is recovery of damages when you're in a breach of covenant. And so you would use that for breaching a covenant. All right, account. The action of account lies, and we probably won't, well, there are some. It would be, a covenant is going to be something that's breached under seal. So if you have something that is not done under a seal, it wouldn't be a covenant. It would be more of a contract than it would be on a covenant. Because that's the difference between a covenant and a contract. We can contract all day long, but a covenant is going to be a promise under a seal. Account. The action of account lies where one has received goods or money for another in a fiduciary capacity to ascertain and recover the balance due. It can only be maintained where there is such a relationship between the parties as to raise an obligation to account and where the amount due is uncertain and liquidated. So if you're getting monies in a fiduciary capacity, so account, that is when you're not trying to recover it for yourself, you're trying to recover it for someone else. So maybe you have a parent or a child, someone that you are a fiduciary of, that you would be taking care of their stuff. In practice and equity, jurisdiction concurrent with the courts of law is taken over matters of account. Okay, so basically in practice, the one on account is the matters of account, which is the one we just talked about. The jurisdiction that's concurrent with the courts of law is going to be equity. And so in practice, that's going to actually fall in an equity court. Equity is the ecclesiastical side of jurisdiction. And so for us, on our common law, we can deal with any of those, but equity and common law, I don't know how to explain this. There's times where equity and common law mesh. It's where they cross paths. Equity will hit up and butt up against the common law every now and then, and it's not very often, but there are a couple times, and so they actually almost mesh. And he's trying to explain that there. He actually does a much better job of explaining it in his video than I am, but that's why it says jurisdiction concurrent with courts of law is taken over matters of account. So our courts of law overtake that, but in the equity is where is the jurisdiction for account if you're in the de facto. In addition to these peculiar grounds of jurisdiction, equity will grant a discovery in cases of account on the general principles regulating discoveries and will afterwards proceed to grant full relief in many cases. So basically what they're saying is when you deal with account, because common law and equity actually mesh right there in a fiduciary capacity, that when they mesh, you may want to not use the common law, and you may actually want to go into a court of record, a court of equity for your case, because if you need discovery, you will get discovery in the equity court when you're dealing with the action of account. And so we don't have discovery in common law because all of our stuff comes in when we write our court of record and send that court of record in. All evidence with that court of record goes in at that moment. So there is no discovery in common law. But he's just saying you can choose to actually use an equity court because their rules when you're dealing with a matter of account will actually be real close to common law in that one case, or in that type of case, the fiduciary case. In practice, at law. So if you do it in equity, you get discovery. If you do the cause of account at law, which is in common law, the action lay against bailiffs, receivers, and guardians in socage only at the common law, and by subsequent extension of the law between merchants. All right, so all right, so it's telling you who the actions are going to lay against on those cases: bailiffs, receivers, guardians. I don't know what a socage is, guys. I'll probably have to look that up. All right, number 10, special assumpsit. This is for the recovery of damages for the breach of a simple contract, either express or implied in fact. The term special contract is often used to denote an express or explicit contract as contrasted with the promise implied by law. Consideration is the test of whether there was a sufficient ground to enforce the promise. It is the proper remedy for a breach of a simple contract or unsealed contract, whether the contract is verbal or written, or whether it is for the payment of money or for the performance of some other act as to render services or deliver goods, or the forbearance to do some act. It's a promise either given in fact or implied by law is essential. So special assumpsit would be, so for instance, for me right now, I'm dealing with a contract issue at my job, and so my job is in the middle of a breach of contract. And so since my job is in the middle of breach of our contract, this is where mine would fall under a simple contract because the contract has not been honored by the other party. And so you are looking for remedy of that. And so that it can be verbal or written, and that's special assumpsit. And then indebtedness assumpsit. Indebtedness assumpsit or general assumpsit is brought for the breach of a fictitious or implied promise raised by operation of law from a debt founded upon an executed consideration. The basis of the action is the promise implied by law for the performance of the consideration or from a debt or legal duty resting upon the defendant. Okay, so this is when it's a breach of a promise. So there's a promise that's been made, and basically it wasn't performed. So it wasn't performed, and basically it all rests upon the defendant because the defendant did not do their part of the deal. Let's see. I don't see non-assumpsit on here, and that's missing. I thought I had them all in here. And then this part right here is just this is like taking the entire court of record and bringing it down to what it would look like based on your pleading. So you would have your name of court, your venue, your commencement, like your commencement's your comes now, Kimberly, an American State National, a woman living on the land and soil, and then you go through those. So these are the things that when you guys are doing a court of record, these are going to be the things that you are going to look at to know what your charge is or what your cause of action, which is a charge, what it would be. For the most part, most of the ones you guys have are not going to be cases that are going to go in on like malicious prosecution or some of the other charges that would be charged, because these are in direct correlation to challenging jurisdiction. When you challenge jurisdiction, these are the causes of actions that come from that. All right, so what I'm going to do now then I'll come back to you guys. At this moment, that's all I have. I'm just going to go over that little piece. A lot of this is huge to digest, and so I'm going to open it up for discussion, questions. I know there's many of you working on things. If you have any questions on how these things work or anything, I'm opening the floor.
This is Robin. As far as my Z-tag, my placard was taken during a stop, that would be Replevin, correct?
I think so. Let me go back. Hang on. Let's go look at it. Immediate recovery of property. Yeah, there it is. Immediate recovery of property plus damages. So you might need to add that one in there because they did take your placard. I mean, I know they're $25, but they're still $25 and it's yours.
That's my point. I've been requesting it to be returned to me, and that is also being ignored. So
yeah, I would add changing the stuff. I would add that to it. It would only take you would only have to add a couple little paragraphs. You know what I'm saying? It wouldn't even take much.
Right. Okay. Thank you.
Yeah. Yes. Do that. All right. Does anybody else have any other questions on common law, on this stuff, on jury, on anything?
Hey, Kimberly, can we get a copy of this document that you've been teaching from?
Yes, this is actually Bill Thornton's Study Guide 101. Did I send you guys this? I think I did, but I'll resend it again.
Okay. Thanks.
Hang on. Whoops. Anybody else got a question? Comment? Questions on jury? Other things that I can go through, hang on this, that is good is, guys, let me get all the way up to it. Yeah, I've taught through a bunch of this stuff with you guys. I just did it from VSOF, and so his is more condensed. Because we went through honor and dishonor, how we always have to remain in honor or do our best to remain in honor at all times. Oh, something else that was on here too. Hang on. When you're given your facts, when you're given your facts, there it is. So when we give our facts of our case, we are not, because it's common law, we can give no evidentiary facts. You see that? We can't give evidentiary facts, inferred or implied facts. So if it's not something that we can corroborate or there's witnesses of or that we don't have in writing somewhere, if it's hearsay, we can't put it in our case. It has to be the ultimate. So our thing is, this is common law. Common law, we use only ultimate or operative facts in our stuff. If it's not a fact. So what is a fact? Who, what, when, where. They say who, what, when, where, how. We don't use why. If it's who, what, when, where, how. And if you see why is not there, and the reason we don't use why is because then you're speculating. When you say why, well, so-and-so did this because the why usually implies intent. And most of the time, we don't know what someone else's intent actually is. So the why of the matter, we don't actually go after. We go who, what, when, where, how. We also can consider facts. Anything that you hear, if you heard it, you saw it, you felt it, you tasted it, you smelt it, the mental state of such a thing. So you can tell from your opinion or from your senses. Like, well, for instance, you can say, I heard my mom. Well, you didn't actually see your mom, but how did you know it was your mom? Well, if you know your mom's voice, then you can say, I heard my mom, or the taste. If the smell in the air, let's just say that, there was something that they released in our air and you're in the middle of a case trying to give testimony or something, and you could taste or smell like copper or, then there's some chemical. That would help. I tasted this in my mouth. Well, somebody might know that, if there's some chemical that taste would come in your mouth, or a smell, or your mental state at the time. So you can go over those types of things. Those are where your facts are going to, when you have your facts and your court of record, that's what we do. So when you're reading over your court of record, and if you come in and you've got anything that's hearsay or anything that's not fact that you can prove, then you can't put it in the case. And then you'll go through your injury and then your demand for relief on those. But yes, that is key on us. We don't deal in hearsay and stuff we can't prove in common law. All right. I know there was something else I was going to show you guys. Those of you that are doing your cases, I went through this with Ashley. It's really good. If you look at the law of the case that we did for Jural, if you go look at the citizen section versus the non-citizen section of the law of the case, it has some really good, the law of the case has some really good subsections. I suggest that you just keep that and not label it, Cheryl's law of the case, but that it'll be everybody's law of the case. We'll just use that same law of the case each time. Unless you have a small case and you just want to copy paste, you can actually make your law of the case smaller. If you don't want it to be 63 pages, you can actually go and you can go in and copy paste those out. Where's the law of the suit? There it is. So I think that what will help people in common law, honestly, if you go through here and read through some of these headings, like citizens versus U.S. citizen, because this shows state citizen, and it wasn't until I read these and just started going down here and reading some of these. Here it is, citizen of the United States. When you read these and then you read what a state citizen is, we have plenty of case law that shows the difference between a state citizen and one of those that is a U.S. citizen. And using any of these in our case will help us, because that's where they get us. They try to make us a U.S. citizen, but we are Arkansas state citizens. We're citizens of Arkansas. We say American state national, but what it means is you're a state citizen or a citizen of that particular state. And because of that, we are owed the guarantees of the Constitution. We have rights, and a U.S. citizen does not have rights. They have privileges and benefits. And so you have the U.S. citizens that have those. Then there's a third class of citizen, which is the 14th Amendment citizen. And the 14th Amendment citizens are the ones that came out of slavery, and they actually don't have rights either. They have benefits as well. So these are really good to put in your case. I think that it's good to read some of these, and they have them in subsection. They're all in like subsections so you can find them. We probably need to write a index page for them so you know which page they're on, but that's those. All right, guys, any other questions, any other comments, any other thing? Any question at all? Anything that you're confused on or that you might have wanted to have me do a discussion on anything to do with common law and what we're doing.
Hey, can you hear me, Kim?
I hear you.
Yeah, I wasn't able to get on. I do apologize for that. It looks like you're going through some. What paperwork are you going through?
Okay, well, I did hear you, but then there at the very end, I
Okay.
Can you
For
hear
some
me
reason
now?
your volume. Yes, that's better.
Yeah, I'm trying to be on a Bluetooth because I'm at work, but I'm actually on phone to hear. For some reason I can't get audio, but I'm also looking at the picture as well. At least I was. Anyhow, I was just trying to see what you guys were doing tonight. What are you overlooking?
So we went over, so I have quite a few people who are doing challenge jurisdiction and quite a few who are doing court of records right now that are getting their stuff ready to come to our court, like come in our court right on the heels of Cheryl. And so I'm just kind of going over some of the stuff that if you're going to make charges against someone after you've challenged jurisdiction on them, there's certain charges that you can do. And so you've got to almost look over that list to see which ones apply to you and how do you plug which one affects you or not. There's about 10 or so different ones.
Perfect. So we'll be able to have some examples at least to go by?
Yeah. And so I kind of gave you guys some examples as I went through them, of what an example would be. Some of them are real self-explanatory. There's a couple of them that are kind of confusing, but they don't apply. And so those ones that are confusing, I just simply say, we'll cross that road when we get to that one. Like when we have someone that has a case for that, we'll look into those deeper.
Absolutely. Well, as long as we have something I can look at.
This is in the Bill Thornton's study guide. Now, where I'm looking at on the study guide, it's the last 3 pages of the study guide. So I'll send everybody a copy of his study guide again, but where I was actually getting that information for tonight for you to know which ones to plug in for a court of record were the last 3 pages. So you'll be able to find it quickly.
Okay. Appreciate it. Thank you.
Yep, no problem.
I don't know
Anybody?
I don't know how to mute the mic on the telephone. What is it? *6 again?
I'm not sure. Maybe try it and see what happens.
I'll try it. Yeah.
There you go. That worked. All right. Anybody else have anything else tonight? I know this teaching isn't as involved as other ones, but I've been really busy. But I'm really trying my best not to let anybody slip through the cracks while we're in the middle of Cheryl's case because we have so many. So if you have slipped through the crack, call me, text me, email me. We've tried to stay on top of the ones who are working on these right now. So anyway, I don't have much as far as tonight. That's kind of all I've got. So if nobody else has any questions, any discussion or anything, we're going to call it a night early because it's been a busy week and it's still going to continue to be a busy week. So anybody else have anything? Question, comment, anything whatsoever? Floor's open one more time. All right, guys, if nobody's got anything, it's just give me a call, text me, email me. We're doing great. I just want to tell everyone how proud I am of you. We are doing fantastic, and we're going to keep moving, and I'll see you on the next one. Good night, everybody.